shame, my lord, of what has transpired for the last 1 week for 10 days, my lord. I would bring to your lordship's notice two aspects of this matter regarding Archie Kaur, my lord. One is, my lord, day before lordship is aware there was a football match that was supposed to be held yesterday between Mohun Bagan and East Bengal. That's a big derby of Kolkata football, my lord. On 17th evening, All India Football Federation, which is a private body, of course, receives information from the authority, police authority, that adequate securities cannot be provided. So the match got cancelled. It was not rescheduled. The match got cancelled. The tournament was transferred to Jamshedpur. That is a separate question altogether. Points were divided. Now, I'm not on that, Malad. Yesterday, when the day before, when the match got cancelled, Malad, the supporters of both the clubs decided that they will go there, assemble, and they will chant justice for RG Kormalan. Peaceful. More than 85,000 spectators who were supporters from both the clubs, and also Mohammedan Sporting Club also joined in, Malad. They were there, Malad. They were stopped 2 kilometers before the stadium, Malad. Lathi charge was there, Malad. More than hundreds were arrested. Apparently, on a phone call that was intercepted by the police, which was never been made public. That interception says that there will be acid bulbs and petrol flares that will be thrown at the stadium, so on and so forth. And unfortunately, Millard, till today morning, Millard, yesterday there was a press briefing by the Commissioner of Police, Vidhannagar Commissionerate, saying that we are taking steps, etc. But till now, in the morning, before I'm mentioning this matter, before this bench, Millard, there is no notification which is prescribed under 163(2), Millard. If I to accept that there is a notification that has to be, Millard, given, that has to be given ex parte under subsection 2 of the new act, Millard, there is nothing published on the website, nothing circulated to any of the major media houses. Only a press briefing was done after the incident happened, my lord. So I would like your lordships to take suo moto cognizance of the matter. If your lordship wants us to make an application, my lord, I would, being a life member of Mohun Bagan Club, my lord, I would like to move this in person, my lord, whenever your lordship allows me, my lord.
What is the relief you?
My lord, the relief I am seeking is, my lord, are twofold, my lord. There's another notification I would like to club this. That's the notification of Calcutta Police, my lord, the police commissioner, my lord, on 17th itself, my lord, withholding and restraining rallies, processions, etc., my lord, because the entire country, my lord, now is in favor of the victim who has been brutally raped, murdered, my lord, and the police. The matter is, this bench is in session of the matter. The CBI is investigating at this juncture, my lord. This is what the cops of Kolkata, who has lost, they do not have any semblance of shame left in them, my lord. If I may, Lordship will kindly excuse my expression, my lord. This is what is happening, my lord. Today, my lord, this is the second prayer, my lord. I will make it a composite application if your lordship wants, my lord. These two, my lord, there is a provision under 163(5) to make an application so that the executive magistrate has the power to rescind, change, or alter the decision, my lord. There were attempts to make application because this is a new act and a lot of people did not know the provisions, my lord. They approached and they were shooed away virtually. This is how they are treating this whole thing, my lord. Women have been beaten up, my lord. But it's absolute anarchy, my lord. If I say so, my lord, it is an absolute anarchy, my lord. I feel ashamed being a part of the system, my lord. I'm an officer of the court, my lord. We have to deal with legal matters every day, my lord. We also at times accept brief for the accused. People who practices in the criminal side do accept brief for the accused, my lord. But this cannot go on, my lord. Lordship has taken a cognizance of the matter. Matter has been referred to the CBI, my lord. But police has to act judiciously. Raj Dharma is the whole purpose of the police now, my lord. As it stands, my lord, today, the whole country, starting from everybody, even in Times Square, my lord, they have held protest, my lord. In Atlanta, they have held protest, my lord. It is all over the internet, social media. Everybody is seeing, my lord, what is happening, my lord. And this is how the police acts.
All right, we'll grant you leave to file the petition.
Grateful, my lord. And one more thing, my lord. This is not related to the matter, my lord. Today, my lord, the lawyers of Calcutta High Court, my lord, without any, my lord, color, banner, flag, anything, my lord. Our only color would be this black and white coat that we are wearing. We worship this for the last 25 years. I mean, 25 years in this profession, my lord. There are many of our brothers or sisters are here, my lord. All senior members, my lord. We will be holding a peaceful rally starting from gate B at 110, my lord. And this area, this precinct will be, my lord, rallied, my lord, around Assembly House and Akash Mani, my lord. We are aware that there's a 163 also prevailing in this area because this is an administrative block. We have information that police may intercept us. If it happens, my lord, they will take recourse to whatever legal recourse we have, my lord. But if the rally continues, my lord, we may, my lord, some of the members, because once the rally breaks out, my lord, we intend to attend the court and the judicial functioning, my lord, from 2 o'clock. If it is slightly late, because we cannot give a formal thing, because none of the bars are officially involved. The lawyers who are informed and the members of the bar, everybody is a member of the bar, and the general body has also decided on this, my lord.
If there is a prohibitory order, then are you not
I do not know if there is a prohibitory order over here, my lord. There is no prohibitory order officially here. Normally, they do not allow rallies in front of the Vidhan Sabha, but we hold rallies, my lord, because when I am aware, my lord, we take the rallies from, my lord, Red Cross Place and this surrounding area, my lord. We may get slightly late, my lord. If your lordship, my lord, takes this into account and inform the learned judges, my lord, honorable judges, my lord, that if some of our members, my lord, get slightly late, my lord, to come and attend the courts, my lord.
The court can resemble at 2:30.
Or the court can an information be given out, my lord, from your lordship's office, my lord, if the court reassembles post lunch at 2:15, my lord.
30 to 30, make 2:15. Seniors are there.
Seniors will come now. 2:15, my lord. This is all I want, my lord.
This is only our.
So if suppose something is placed in writing, I'll be able to.
I understand, my lord, but you see, my lord, the bar officially is us, but not officially with us, technically speaking, because bar, lordship is.
You can speak to the secretary bar.
We have already, and he has moral support. The other members of the bar also has moral support. It is beyond politics now, my lord. It is about humanity, my lord. It is about the conscience, my lord. I cannot look at the eye of my wife, my lord, for the last 10 days, my lord. My head hangs in shame, my lord. Because it's always a saying, my lord, not all men, but it is always a man. That's the saddest part of this whole fiasco that has happened, my lord.
But we leave with my senior, my lord. We are ensuring that we rejoin at 2. But because the small precincts we are just marching is a silent, that we are silent march, my lord. All seniors will be there. So it's a small rally. But my lord, if we are 5-10 minutes
No,
delayed,
if Mr. Dalapati gives a letter on the administrative side, I can do something.
my lord, this is not a bar, is not taking this
Everybody
resolution.
would have assembled in court now.
My lord, this
we will see what we can do, my lord.
Well,
We will see. And lordship, I will be moving it in person, my lord. I will be preparing and moving it.
We'll grant leave.
Grateful, my lord.
deeply obliged.
My lord,
Seek leave.
I am appear in person. My fundamental right violated by the Calcutta High Court, as the case has been filed by Honorable Supreme Court advice letter against the Honorable Chief Justice of Calcutta High Court, and till date case number not given me, filing number given me, in the matter of violation of Honorable Supreme Court judgment by Calcutta High Court judges, and in the matter of 1946 Foreigner Act violated, and in the matter of Article 235 as per advice by Honorable Supreme Court. And court official told me, go to Honorable Chief Justice Secretary or OSD. My lord, it is my fundamental right. You and I, both Indian citizen, law equal for every citizen.
Rightly so. Please give the letter, you give the letter.
Lordship, may I seek
mention, my lord, this matter, my lord.
This matter is a exploitation of the workers. The workers who are engaged in the Sialda Karshed for mechanized cleaning of the coaches and they are the sub-grade workers. But prison is lying under the public interest litigation. Our last order was on February. Thereafter, your lordship directed to serve all the respondents. They are already served. Matter is on the 1st August, item number 1110. My only prayer is that agreement is going to be expired, my lord, sooner and earlier. My relief will be then, it will
To
be.
the letter, we'll try to
My lord,
update.
I have
Lordship, my son, who
kindly,
is
my
a,
lord, let it be
East
upgraded, my
Bengal
lord.
supporter, he was willing to go for the yesterday's protest when the match got cancelled. As my learned senior mentioned recently, has been picked up by Satragachi police station yesterday afternoon. Since then, no whereabouts is given by the police where he is. Equally, Lordship, there are others, many others who have been picked up with police. Police are intercepting the mobiles, WhatsApp group messages, and they're picking up the people. So this is one of those incidents, Lordship. Kindly give me leave to move it at
Can be done.
2
Is
p.m.
there
Lordship.
anybody from the state? Yes, you are for in the state panel. Can you bring the government leader or Mr. Amitesh Banerjee? You please wait.
Lordship.
Lordship, I'm tendering unconditional apology, my lord, that I'm mentioning this matter again. My lord, your lordship on Friday heard the matter and passed an order regarding RGKR case. My lordship, I'm not blaming anyone, my lord. My matter still is not tagged, my lord, and my name is not appearing in the order, my lord. I'm beseeching before your lordship, let my matter be tagged, my lord.
Actually,
Your
we
lo-
have listed the matters on Wednesday.
Lordship,
Probably on that day, we can correct the order. and
lordship,
include
only
your name.
beseeching if my matter can
Your
be tagged.
lordship, this matter pertains to Arjikar incident, lordship, the heinous. I beg lordship that kindly bring up the matter on Wednesday at least, so that it can be heard.
Give the letter, give the letter.
I already sent the letter to OSD. I bow down.
Yes, doctor.
My lord, I'm here related to Arjikar, but I was here Friday. Your lordship was kind enough to grant me leave to file, but urgent hearing because the hospitals are shut down, poor patients are dying. All I want to stop that strike. I am in total support for justice, but not at the expense of the poor patient. And it's clear violation of Supreme Court. Dr. Strike, we went there. So, my lord, I have served the opposite party. Kindly keep it tomorrow for hearing, my lord, under to be mentioned.
Give the number, we will decide when it.
Yes, my lord, because they will die. So kindly hear me tomorrow.
Kindly grant leave to file a memorandum of application of the certified copy.
Please grant. Yes.
With your lordship's leave, may I mention my application for inclusion? All the respondents are already served. Lordship, this matter was due to appear today, but it is not listed yet.
And I mentioned
Grateful.
application. Of the madam lord, only I was saying lord, the council will be out session lord, may date be fixed, lord, next week, anytime next week.
No, you indicate the date in the letter. Have you given the date?
26th, lord, next month.
All right.
But direction of my lord's order dated 28/8/2023 after the judgment of the Supreme Court that 8th July judgment, I mentioned this matter. My lord asked me to mention this matter. I mentioned this matter, but it was not appeared in the list.
You just give the number, let us see.
It is.
Your lordship, I am mentioning this matter
The
before
judge
your,
also serve the judgment, supply the judgment of the Supreme Court also.
your lordship, I am mentioning the matter due to some exigency. This is my mother. She has filed two CAN applications, one for restoration and one for delay condonation. She is an old widow, 75 years of age and suffering from various ailments. Now the matter is that the case is presently lying under court number 26. And the case was dismissed for default due to the professional negligence of the advocate. If your lordship kindly enter into the matter, you will realize the fact. But what is happening?
But the CAN application has to be heard by court number 26.
Yes, but their lords.
Can you not mention in court?
Yes, the matter came before their lordship on last 16th August. But their lordship is not are not willing to hear the matter from us because he is. Just a moment, your lordship. Their lordship are not willing to hear the matter because she has appointed me as her agent.
Sir. On the administrative side, suppose I have to do something, unless the bench releases the matter, I cannot pull it out. you make a mention for early hearing. Then if any order is passed by the bench, or if the bench releases the matter, then I can.
Your Lordship, yesterday, their Lordship became very angry with me. They warned me that if I say anything more, they will put me in jail. But actually, their Lordship is not willing to willing to obey the validity of such authorization, because I have the Supreme Court ruling in this regard. Your Lordship may kindly look it out. I have one copy. For that I am seeking pardon. Your Lordship may kindly find point number 14, where it has been mentioned that the authorized agent may conduct the hearing. I am also an advocate, and Justice Devanshu Bosak is insisting me to take legal aid, but she has no faith on legal aid, and also the state aid. She is not getting her pension salary from last 2003. And there is a very unprecedented situation with her going on. She is living with unfed.
Unless it is released on the administrative side, I will not be able to do anything.
Your Lordship, kindly guide me. What shall I do? Will I approach him to release?
If you can make a mention before the bench saying that we mentioned before the court number 1. Court number 1 has directed you to mention before the court number 26, and whatever orders are passed, you then based on that you give a letter. That
This is my humble submission, Your Lordship.
letter to the
Kindly assign the matter before your bench. After releasing.
Lordship, seek permission to mention before your Lordship, appeal against the single bench that they passed an order that I was arrested without a 41 notice. All cases were under 7 years punishment. After the order was, the case was filed under 226, the single action bench, Justice Amrita Sinha, has passed an order warning the IO but not taking any action against her to doing so, and the case was disposed dated 10 July. Moment the case was disposed, Lordship, a police under CRPC 149 has the power to call. They are calling me and harassing me day in and day out. At least 7 times I was called in and sit in the police station. The prayer in the writ petition was that I was arrested without a 41 notice, and as per the Anish Kumar guidelines of the Honorable Supreme Court, that they are to be pursuing a proceeding against the investigating officer. But it was not done. She was let off with a warning. And moment this case was disposed, I'm being harassed right now, Lordship. I've filed a fresh appeal against that in a MAT application.
What is the offense registered in that?
Sections were 387, 509, 506, 354A, C, and D of the IPC. 5 sections are bailable sections and 1 within 7 years imprisonment.
You give the number, we'll list the appeal.
Sure. Thank you, Honored Lordship.
Yes, Mr. Banerjee, what is your friend is saying his son was picked up?
Means, my client's son, Lordship, that he has been picked up yesterday from Santragachi police station, and he's present. His father is present here. Without any thing, Lordship, he wanted to go for the protest, and that's why from afternoon he was picked up.
I'll take instruction. I'll not make an off-the-cuff statement.
That is what we wanted your
presence. If he just gives me a copy, I'll
give that.
Any plain copy, anything would do.
Whatever is.
I'll give the mail. The email he has sent.
You say forward it to Mr. Banerjee.
Because I don't believe in making off-the-cuff statements.
No, you ask them to release them. Yesterday, police initially were.
Let us see for what reason. If you gives me 2 minutes time, I shall come back.
Please verify.
Whenever, when would we
for 12 o'clock?
12 o'clock. I shall be back before Lordship. But exactly what is the situation? Now let me take the instructions.
Grateful.
I'll come back.
Yes.
Affiliate side, daily list, serial number 1. Lord, I am for the applicant, my lord.
I appear for the straight response.
Lord, in dealing with the matter, lordship kindly takes the trouble to see two orders, my lord, pass. First is 1st May and
Yes,
second,
we remember the matter.
yes.
And what happened to the affidavit in opposition?
Neither affidavit of opposition has been filed, even the deed in question, which my lord directed to surrender before the register. Only two original deeds, the deed in question, which is the issue, the certified copy of which was surrendered. Then my lord said by 27, police will ensure that it is surrendered. Unfortunately, my lord, no step has been taken. I loaded.
My lord, already you have deposited the original deeds that has come to my mobile.
So what is the instruction ground pleader?
Till 27th of July, they did not submit the deed, my lord. Then we have registered the cases against them under section 188. My lord, now my learned friend says, my lord, that he.
27.5 he has deposited it.
My lord, but
No, my lord,
the
I have
original
got,
deed, there were 3 deeds. They have submitted only 2 deeds. The 3rd deed they have not submitted.
No,
My-
ask your client to submit the 3rd deed today. Tomorrow we'll list the matter. You just get a report from the
My lord,
police.
I'll take the report. Come.
List tomorrow. Time is granted to the respondents 12, 13 and 14 to surrender the remaining
Well,
one title deed
May I pause for a
to the
moment?
police.
Let it be keep it on fast day, lordship.
Why?
No, I have some difficulty tomorrow and day after tomorrow, 2 days, lordship. Only keep it on fast.
No, your client let him surrender
I have to.
by today,
yes,
by 5 p.m. today. Within
My lord, your lordship may kindly mention the deed number. It is 2947 of 2010.
deed number 2947 of 2010. By 5 p.m. today, within bracket 19/8/2024. List the matter under the same caption on Thursday.
2947.
Next.
2947.
Serial number 2, and item number 2, I am appearing for the appellant.
There's some correction or something.
My lord, I am taking a week's time because, my lord, I have not received the written communication to withdraw the matter, my lord.
Yes, last time
My
somebody
lord.
represented.
My lord, as it is a PSU, my lord, I have not received. My
The
lord.
learned advocate appearing for the appellant requests a week's time to obtain appropriate written instruction from his client. List next Monday under the same caption.
Grateful, my lord.
Next Tuesday.
Next
Tuesday.
Serial number 3 and 4.
Madam, in this matter, I am appealing for the WBS.
I appear for the appellant petitioner, my lord. This matter involves, my lord, the writ petitioner filed a writ petition for electric connection, wherein thereby relying forged document. In the initial stage of the writ petition, we did not appear. Thereafter, order was passed. Subsequently, filed an application for recalling the order and thereby praying for proceeding on the 340 of Indian Penal Code has to be initiated on the Code of Criminal Procedure to be initiated. Since forged document was there, there was a direction for affidavits. In the affidavit, my lord, it was specifically admitted that those documents which we are saying the forged document were proper. They did not deny the contention. In spite of which, the 340 proceeding was not initiated, my lord. Since already another proceeding was done by the learned court below, for which the application under 340 was rejected, challenging which I prefer the appeal before this court, my lord. Now, the difficulty is, my lord, two things, my lord. Affidavit service. Affidavit service.
Order basis আমরা যেন কানেকশনটা দিয়েছি কোন order basis?
Second order, second.
Date কতটা? In terms of the order date আমরা কবে
এটা না, এটা কোনটা, এটা সেকেন্ড অ্যাপ্লিকেশন, সেকেন্ড অ্যাপ্লিকেশন, সেকেন্ড রিটেল
order দিতে মানে আমরা যে কানেকশনটা দিয়েছি ঠিক আছে বলো
ছয় জুলাই 2022 6 জুলাই 2022
আমরা কানেকশন দিয়েছি 24/8 6 জুলাই, তাই তো? ডব্লিউপি নাম্বার এটা কি ছিল?
129
सब हाथ कर
certificate enlistment certificate. Your interest is protected. Kindly visualize one thing. A person comes with a forged document before this court of law. It's a record.
No, no, no. The court has recorded a finding with regard to that aspect of forgery. Please come. No, no, no. Please come to para 20, page 6 of the impugned order.
আমাকে সাপ্লাই করুন। প্যারা 20 বলছি, প্যারা 20 is 6.
Para 20, then para 22. So the court has only decided whether it will amount to forgery as contemplated under 463. Ultimately said that the court doesn't find it appropriate to direct an inquiry to be conducted or refer the matter under 340 CRPC. However, said that any of the observations will not be a bar or will not operate against your client if any other criminal case has been registered and if an investigation is going.
My only contention before your lordship, my lord, a person comes with two writ petitions, with two times he have produced those forged documents, obtains orders from the court. These are on record, and in the opposition he has not denied those.
See, that is what
kindly consider that inquiry has to be done by the police authorities, whether those are.
There are two documents. One is a certificate of enlistment. The other is a leave and license. The court examined those documents because in one thing, the word provisional is there.
The original was the word provisional and a date was marked that was wiped out. The word provisional and the date was.
Their plea was there was flood, etc. The documents got damaged. So this is a question of fact.
That has to be inquired by the police authorities, my lord.
You lodge a complaint. That is why in the last paragraph, you please see the last paragraph, 32, that protects your interest.
Well, those are, my lord, a person who comes twice before the court with unclean hands, my lord. My only contention was that a proceeding has to be initiated, whether let him answer before the appropriate authority, whether it was taught, because that cannot be decided without trial. We are not saying that this writ court can decide on these issues. A proper inquiry should be if he finds that these were not proper.
Prima facie, we find the observations made by the court, more particularly in paragraph 22 and 23, is after thoroughly examining the factual position. In an intra-court appeal, we find nothing perverse to interfere in this. These intra-court appeals are by a third party, by a applicant who was a private respondent in WPA 129111 of 2022 and WPA 16770 of
If my lord so desires, my lord, let me come with an application bringing those documents before your lordship. If my lord so kindly adjourn so in that event.
The applications were filed by the appellant herein under section 340 of the Code of Criminal Procedure, alleging that certain forged documents have been annexed to the writ petition and statements have been made in support of which support thereof, which are false and intended to practice fraud upon the court. The court elaborately considered the various provisions of CRPC and then proceeded to examine the facts and has recorded the following finding. With regard to the two documents which, according to the appellant, were forged documents. At this juncture, it will be relevant to take note of paragraph 22 and 23 of the impugned order, which are quoted here and below. Please quote paragraph 20. On a careful examination of the finding recorded by the learned single bench, we find that the learned single bench had examined the factual position and recorded its finding, which we are finding, and we are of the view there is nothing perverse for us to interfere with the said finding in this intra-court appeal. That apart, in the penultimate paragraph of the impugned order, the rights of the appellant have been sufficiently safeguarded, wherein the court has observed, wherein the learned writ court has made it clear that the findings have been rendered in the limited context of dealing with the applications under section 340 CRPC and are confined to the allegations pertaining to whether the ingredients of the said provision are attracted in connection with the dealings before the court, and nothing in the observation shall prejudice the outcome of the independent criminal cases or investigation, if any, otherwise going on against the writ petitioner on the complaint of the appellant/applicant in respect of the self-same documents. Thus, we find no grounds to interfere with the impugned dismissed. Both the common orders of 3 and 4. Sorry, next.
Serial number 527.
Dismissed, my lord. This matter is dismissed.
I beg to appear for the state, my lord.
Dismissed or dismissed?
Led by Mr. Learned Advocate General, my lord. As I intimated by the AG office, my lord, he is still not recovered. Lordship is pleased to.
Madam Advocate made a submission and it's for me to give the reply.
So in his presence, it is better.
Yes,
When,
this required, my lord.
when the learned advocate,
After 3 weeks, my lord.
3 weeks,
No instruction.
there is no urgency in this matter.
Urgency was there because of adhesion for the client.
Accommodate himself, please. Adjournment is sought for on behalf of the learned advocate general. Give a date after 3 weeks.
Serial number 8.
May I retain the same position on the next
Under the same caption.
or copy kollo?
Serial
On
number
which
8.
date, madam, may I only note the date?
3 weeks.
3 weeks.
Oh.
Or the 6.
I'm grateful, ma'am.
I'm grateful, man.
8, my lord, I am appearing. Well, there are few corrections in the order.
What is the,
But yes.
in the photocopy, if you correct and give it?
Yes, I have done that. My lord, only dates, my lord. Because the initial order, my lord, in appeal, it was passed on 23rd of December. Yes,
Give
my
the photocopy.
lord, I have given. There are 4 dates which are needs to be corrected, nothing else. From the next page.
So the MAT number is also wrong.
Yes.
2017.
Yes. And my lord, the first correction, my lord, the order, initial order, which was passed up in appeal, it would be 23rd of December and thereafter 3.
The matter has been listed under the caption to be mentioned and pointing out certain corrections in the case number and 4 dates.
4 dates.
In paragraphs 1, 3, and 3.
Dated.
The case number shall be corrected as MAT 1803 of 2017. This order shall form part of the order dated 6/8/2024 and the corrections be effective. Next.
Great.
Serial number 9.
I was appearing for the alleged container in 8.
And I appear for the appellant on the last occasion. I appear for the respondent writ petition. And your lordships have been pleased to, my lord, direct. May I file the report, my lord? Lord, we have received a copy of, my lord, the report. Lord, we have by a letter, my lord, written to my learned friend, my lord. Most of the pages of those report, my lord, 10 pages are illegible. So we have asked for, my lord, the.
I'm making. Kindly.
It's now just been handed over. Now, this is with regard to construction of not a pipeline overhead, not the railway underpass, not that right of privilege. That's the issue, not the factory will be running out of water after some time. We are somehow managing. If your lordship kindly fixes it up next week or subject to lordship's kind consideration any other day.
Exception. Lord, we're in the process of filing an exception. We shall do so in the meantime, Lord, and serve copies.
All right. Report on behalf of the railway administration has been filed, copy of which has been served on the learned advocates for the parties who pray for time to file their exception. Let such exception be filed during the course of by Friday.
Lord, 1 week's time, Lord, because these have technical presentations.
Shall be filed within a week from date. List the matter on so and so date.
Third or fourth, not that week.
Serial number 10.
Not could it be on the first week of September if it's so common?
Anytime.
First week of September.
Next, serial number 10.
Serial number 10.
This is the first time it is coming. Fresh matter 2025. Okay. All right, sir. None appears for the appellant. Give a date after 2 weeks.
Serial number 11.
11, my lord, is my appeal, my lord. On the last occasion, my lord, the lordship had directed us to serve. Lord, the respondent, lord, my advocate on record, my lord, I don't find, lord, I don't know whether it has been served or not, lord. I think it should have been in the meantime, lord, since nobody is appearing.
Vidyut Kumar Halda.
Yes.
The learned advocate for the appellant requests time to complete service of notice on the learned advocate appearing for the contesting respondent. List after 2 weeks.
Yes.
Serial number 12 and 13.
Yes.
My lord, I am appearing for in both the matters for the appellants. My lord, in the last 2 occasions also the respondents are not appearing. The lordship, I would give a notice, and if the matter can be fixed after 2 weeks.
All right. The learned advocate for the appellant is directed to serve notice on the learned advocate who is appearing for the.
Your lordship, it would be better if I give the notice to the respondents because the Competition Commission of India is the respondent. So it would be better.
Who will appear normally for the competition?
Your lordship, in this matter, Mr. Tilak Bose was appearing for the commission at the first instance, and thereafter the then additional Solicitor General Ms. Diwan was appearing for Competition Commission. Yeah.
Already you serve the respondent.
I serve the respondent.
In addition, if you can give copies to the.
Your lordship, we'll do that.
The learned advocate for the appellant shall serve fresh notice on the respondents, and in addition, serve copies on the learned advocates who appeared for the respondents before the learned single bench.
Grateful, your lordship.
Give a date after 2 weeks.
Grateful, your lordship. Much obliged.
Serial number 14.
Your lordship, I am appearing for the appellant, your lordship. Your lordship, on the last occasion, with humble apologies, your lordship, we had sought time for rectifying the defects, your lordship. We are to file one section 5 applications, your lordship. It's there, just the affirmation.
Today, we'll have it next week.
Next week, your lordship.
All right. Leave is granted to the learned advocate for the appellant to file the application under Section 5 of the Limitation Act during the course of this week. List next week under the same caption. Next.
Serial number 15.
Three appears of the respondents. And it's on last occasion, since AG was not, learned AG was not well, they have taken time.
AG was appearing this
Yes,
already. It is submitted that the learned advocate general is appearing in the matter, who's not available. Give a date after 3 weeks. They told that he will be able to join after 3 weeks.
Serial number 16.
None appears for the appellant. Give a date next week.
Serial number 17.
Same order.
Serial number 18.
I'm not a respondent in petitioner.
Why today nobody is appearing?
We are not in a position to proceed the contempt application also, since the appeal is pending. Not today.
None appears for the appellant.
Not make it not today.
All right, not today.
We can keep it.
Serial number 19.
Not today.
Serial number 20.
And I'm for the writ petitioner's appellants.
25.
Respondent CESC served.
Served. Ability to service.
After September.
Served on all concerned. All the respondents.
Oh, the advocate was here for a couple of matters before. Mr. Rai was here, Om Narayan Rai.
Well, the matter concerns as to whose name an electricity meter would devolve after the death of the original consumer. Well, in this case, the petitioner number 1 is the son of the deceased. The petitioner number 2 is the widow of the deceased. And one of the private respondent happens to be the married daughter of the
Next week.
of the deceased. Well, what happens after the death of the original consumer? The private respondent, who happens to be the daughter, somehow manipulated with the CSC Limited and got the meter transferred in her name, exclusively in her name.
Serial number.
The son was there, the widow was there, but she got it somehow got it transferred in her name by manipulating with the CSC. Immediate and even a bill was issued specifically mentioning that she is now the meter lies in her name. I have enclosed that. Immediately on getting to know of this, the appellants, that is the son and the widow, immediately approached the CSC and they came up with a second bill for the next month, reverting the matter back to the name of the deceased. Now the private respondent as writ petitioner approaches the writ court, and Justice Shobhushachi Bhattacharya of this court observes that let the meter remain in the name of the deceased till the civil disputes and partition suits are sorted out in between the parties, all the parties, and directs the party, that is the writ petitioner private respondent hearing, to approach the GRO, grievance redressal officer, in order to sort out the issue of splitting of load only. That transpires from the order passed by the Honorable Court. Now, what the GRO does, the GRO does not decide the issue of splitting of load. I was not given a notice. The GRO does not decide on the issue of splitting of load, but the GRO comes to an observation that she has a right to have a electricity connection in that premises. She is a cancer patient, so let her enjoy the electricity meter in her name. We prefer an appeal before the learned ombudsman. The ombudsman says that the GRO didn't do it right. The GRO should have dealt with the issue in question. The GRO did not decide on the issue of splitting of load in terms of the observation made by the Honorable Court. The order seems wrong, but okay, let the meter revert back in the name of the deceased. But in the event the lady, that is the private respondent, married daughter, she comes up with an application, it will again be changed. The meter will again be changed in her name. That was done. Challenging that, I came up before the writ court again, and the Honorable Justice Khampa Sarkar, Lordship observed that let it continue till it is already in her name, let it continue till the civil disputes are sorted out.
No.
And I am here.
So suit for partition, is it?
Suit for one, there are two suits. One is a suit for partition between the legal heirs of the deceased, And the second one is the married daughter somehow coerced my mother and got a gift deed transferred, transferring her 1/3 share in her name.
Mother's
mother-
1/3 in her.
My mother's 1/3. So that my mother has already filed for a suit for cancellation of gift deed.
All right. In
So
both,
these two are
both,
pending.
both the suits, are there any interim orders?
There are no interim orders.
CESC is not a party to the suit.
CESC is not a party to these suits.
But under what circumstance, probably with that gift deed and legal heirship certificate,
My lord, even let us for the sake of argument, my lord, in the event she succeeds in the gift deed, the private respondent succeeds, she gets 1/3 of my mother's.
her 1/3 share.
Her 1/3 share is there. 1/3 of 50%. My father had another brother. He died intestate, and the brother had gifted his half portion to me. So I'm automatically having honor of half and 1/3 of my father. And my elder sister, who is the private respondent, can be 1/3 automatic and 1/3 from my mother if she succeeds in the suit. Otherwise, she has only 1/3.
Even as on date, accepting the case of the sister,
My lord,
your share is more than.
my share is much more. I am not standing in the way of her enjoying electricity. For once, I am not at all standing in the way of her electricity. My only point is, my lord, let the meter revert back to the name of the deceased father till the issues are settled. Or let the meter be recorded in the name of all three. Married daughter, my mother, and
Before the change of name,
my lord.
were you heard by CESC?
No. I have endorsed that. And when I approached the CSC that how my mother, she's a spouse, there's an offline application form from CSC by which only a spouse can change the name. You didn't even bother to
Well, then it was
ask for
reverted
a.
back, my lord.
Yes.
Subsequently, it was reverted back to the objection made.
That's what
My
is
lord,
submitted
kindly
before
come
your
to the order impute paragraph 4 and 5. Well, after that, I think my learned friend should not have any objection to this. Kindly see paragraph 4 and 5. Their right has been protected and he could not show a single document which will prove that the respondent number 6 has got no share in the property.
I'm not denying that.
See, there are two ways of doing it. One is it can revert back to the name of the deceased, or it can be in the joint name of these three people.
I'm agreeable to both.
But why do you take sides?
No, we are not taking sides,
Then,
madam.
as
Well,
a-
we have
as a
already
generation company or a supply company, before effecting change, if all the legal heirs come make a joint application, there is no dispute, no issues. But here apparently there appears to be a dispute, and she is in possession of a registered gift deed. And undoubtedly she is a shareholder. But then you should have heard the other co-sharers before shifting the meter exclusively in her name.
Madam, as far
what
as
is the
my
present
instruction
position?
goes, madam.
No, what is the present?
Present position, madam, we have implemented the order of the ombudsman. Whatever is there, we have
And meter
implemented.
is
Before they
exclusively
filed,
recorded
before,
in the name of the
before
deceased
they
daughter.
filed the suit, my writ petition, last writ petition, we have already complied. And that was brought before the honorable single bench, madam. Madam, if it has fallen from your lordship, madam, may I come back with instructions?
Well, even the GRO's order and the ombudsman order, the ombudsman
But what
observes
is-
that the GRO is wrong.
You produce the concerned file noting or orders by which you transferred this exclusively in the name of
Madam,
the
what happens,
daughter.
madam, we generally get online application for transfer with certain upload documents. But on the basis of that, we have transferred. The moment we
No,
got,
you could not.
on the moment
And
we
my
got,
lord,
The document contains a legal heirship certificate and the application has been made by a single individual, then you ought to have put notice and issued notice to the other co-sharers of the company.
madam, give me some time, madam, I'll come back
and
with
the CSC
exact
did not
instruction.
even bother to
Let her
get a
enjoy.
NOC.
Let all of them enjoy the electricity supply.
Yes.
You don't get into their civil dispute.
No, we will not. Madam, will you kindly give me some time, we'll come back with instructions.
Have you served the
Served, my lord. I have filed the affidavit of service. I have served the married daughter in both her addresses, in this premises as well as the married.
appellant and the learned counsel for CESC Limited? Though the private respondent has been served, none appears for the private respondent. The question which is required to be considered in this appeal is whether CESC Limited could have transferred the electricity service connection exclusively in the name of the private respondent, the daughter of the second appellant, correct?
The daughter of the second appellant.
Second appellant and brother of the first appellant. when the appellants claim a share in the concerned property, all being the legal heirs of the deceased Rabindranath Methi. It is not clear as to how and on what basis CESC Limited transferred the electricity supply from the name of the deceased, namely Rabindranath Methi, in favor of Sumana Adya, alias Sumana Methi Adya, the sixth respondent, who is the daughter of the deceased. Admittedly, civil suits are pending between the parties. However, in the civil proceedings, CESC Limited is not a defendant. We direct the learned advocate appearing